Disney wants a wrongful death suit brought on by a man whose wife died on a trip to Disney World, dismissed on a technicality. Here's what happened. Jeffrey Piccolo, his wife and mother were on a trip to Disney World when his wife, Amy, had a deadly reaction to food in a restaurant. This is all according to the lawsuit. Piccolo says they made it very clear she had a severe allergy. They were promised her food was safe. Disney isn't disputing any of those details, but they are saying this family can't sue because of a Disney Plus trial subscription that he signed up for back in 2019. They want the wrongful death suit seeking at least $50,000 in damages thrown out entirely. Back with us now is trial attorney Misty Marris. Misty, me and the team have been talking about this. Help me understand what Disney's case is. Why are they saying they can't be sued in an incident that has nothing to do with a Disney Plus subscription? It seems cruel even.
Yeah, so Hena, I don't know about you, but when's the last time you ever read the terms and conditions on any of those apps when you're downloading something to
Never.
watch television? You would never think that you're waiving a right that would be applicable when you set foot into an amusement park. So here's what Disney is saying. They're trying to get the case thrown out of court. So the case would not be heard by a judge and a jury, but instead it would be heard by an arbitrator. And there's a reason for that. From a defense perspective, arbitration is generally more favorable because a jury is going to hear this tragic story, hear about the loss of a loved one, and they're going to be sympathetic. In arbitration, it's heard by an arbitrator who's a little bit more dispassionate and will focus on those minute legal issues. So that's the rationale to move it to arbitration. But looking at this language in the terms and conditions of the app, it is certainly a stretch to say that that's going to extend to actually physically being at the park. They're trying to use the fact that the ticket was bought through the online platform that the app exists on and the downloading of the app in 2019 as a basis to enforce what they say is broad language. But it's really unlikely to succeed. And this case is probably going to end up back in court before that judge and jury.
I'm going to share an analogy that our producer David made when it comes to The Little Mermaid, since we're talking Disney, a Disney movie where the villain Ursula gets the Princess Ariel to sign a contract. He really doesn't understand the implications. But is this exactly the same thing? How strong is the doctor's case that he should still be able to sue, even, to your point, if it was in the fine print?
I mean, I love the Little Mermaid analogy, and it really fits the bill because the general principle in this case is that it's contract law. So anytime you sign terms and conditions, whether it be signing up for an app online or a television platform, or whether or not you're buying a ticket to the amusement park or buying a ticket to a concert, those terms and conditions are contractual. But there are limits to how far those terms can actually be extended. There's various principles in contract law, one being when something is unconscionable, meaning there's unequal bargaining power between the parties. Obviously here, if you want to sign up for a platform, if you want to sign up for Disney Plus, it's not like you're going in there and saying, you know what, I don't really agree to this term, I'm going to exit out. No, you either sign it or you don't. So the way that contract law works, unless something is explicitly in writing, very, very clear, then it's known as ambiguous. And when it's ambiguous, the court looks at it and says, what would a reasonable person think about the intent of the parties? So basically, you can't have somebody run away with all of your rights just because you're basically forced into signing this type of agreement and agreeing to those terms and conditions.
Misty, I'm running out of time, but I have so many questions to ask you. I'm going to try to rush them in. Why is Disney focusing on the Disney Plus subscription terms and conditions, but not the terms that are included when you buy that Disney World ticket?
So I took a look at those terms on the Disney ticket, and they're very, very limited to incidents relating to COVID-19, which makes sense after the pandemic and other communicable diseases. Because that's so specific on the ticket that those terms relate to COVID-19, that would be immediately thrown out in court. The difference between the language on the Disney Plus app is that it's a bit more broad. And so the argument is because of that broad language, this type of scenario, a personal injury in the park, would actually fit under that language. But again, You got to look at the whole thing in context, not just that language.
Thanks for watching. Go to joinnn.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.